to be recognized that we're at a very early stage of supported decision-making. It's not that widely implemented, even though the UN Convention has given it high status. There really aren't that many jurisdictions that have a long track record. So in this sense, a very key safeguard for supported decision-making in the long run is to begin to define what it is that we need to have in place that would support decision-making well. For instance, we really don't have a set of principles in aspects of supported decision-making that are all that clear to people, so they might not know what is good practice or not good practice in terms of supported decision-making. Secondly, people can pretty much call anything they want supported decision-making, which doesn't really create much clarity of what the concept is. Thirdly, we have not really applied supported decision-making to large numbers, and so in this sense we're really at the familiarization stage of the process. So in this sense it'd be premature to make conclusions about supported decision-making without some of that evidence in place. Also, many people need to recognize that though supported decision-making in theory is an alternative to guardianship in the long run, our systems actually opt for guardianship first, typically, and in fact it's almost seen as the automatic response. And so in that regard, there needs to be the careful crafting of what are the grounds by which we make the case for supported decision-making as an alternative to guardianship, and what is going to need to be in place to convince people that supported decision-making can be done well enough to preempt going towards guardianship. And in this respect, the supported decision-making challenges around guardianship also relate to the fact that there are many people conceivably that have guardianship now that could have it rescinded if supported decision-making was available to them. In other words, they probably didn't ever really need it, and in fact, there was never any other option offered to people. So in this sense, we have a historical problem that goes back hundreds of years now of the promotion of guardianship as an automatic sort of a normative practice as opposed to something that may now need another look. For instance, there are many forms of public guardianship in which the requirement is that the public guardian or the person in that role has contact once a year with the person. Whereas in supported decision-making, supporters might be involved literally weekly or daily and would know a great deal much more about people. So in many ways, guardianship isn't the protective safeguard that people think it is. In fact, it may create the illusion of safeguarding and not the actual safeguarding of the vulnerabilities of people. So all of this is ground that needs to be charted. There are people that have taken up, for instance, the legal aspects of supported decision-making, things like representation agreements, various forms of power of attorney, various health proxy mechanisms, all of which, again, people may or may not be familiar with, but may soon become familiar with. So a good way to think about where we're at the moment is we're in the early years of supported decision-making as a widespread phenomena. And in fact, we now have, in the United States, this is early 2018, we have 2 states in the United States that have a supported decision-making law. Israel has a supported decision-making law. Other countries have gone down that road. So we're beginning to see examples of legislative supports for supported decision-making. So it's, in a sense, what we're seeing is that there's a great deal of interest in supported decision-making and plenty of scope for clarifying what we mean by it.